Hello and welcome to another segment of Western Wisconsin Journal. I'm Jamie Johnson, the legal and government correspondent, and today my guest is Bob Feidler. Bob, welcome to the show.
Thank you, Jamie, for having me.
Now, to introduce you, Bob, and our topic today happens to be a county board seat in St. Croix County that still has not been filled, and we have voters who have not been represented for over a year.
That's exactly correct.
And so we'll take us back. The election is the spring elections. They're nonpartisan county board elections that are held in the even-numbered years, correct?
That's right. We're going back to the election that was conducted on April 3rd, 2018. So about 15 months ago now for the county supervisor positions. And we're talking about the election that occurred for the district that's basically the southern half of New Richmond.
Okay. And so for our viewers who may not be familiar with St. Croix County Board, there are 19 districts.
There are 19 districts.
And used to be over 30, but they've reduced that down. And so 19 districts, and everyone basically gets elected for a 2-year term.
That's correct. And we're talking about District 13.
And District 13, which is the southern half of New Richmond, as you said, and you were elected in that election.
That's correct.
For the area that basically includes the Troy-Burn area.
Just south of Hudson, that's correct.
And so you were elected, and you're here not necessarily representing one party or the other, but kind of as an observer of the process.
Exactly. In fact, what happened, the election occurred and there was a tie vote, and ultimately the Board of Canvassers of St. Croix County, which is made up of the clerk of the county and 2 other representatives, basically one from each of the major parties, although a Board of Supervisors race is nonpartisan, had to engage in a recount. Well, I'd never been to a recount in all my life, so I thought this would be interesting to go down and see. So I went to the county building, and in a very professional way, Cindy, who is the county clerk.
Cindy Crawford.
Cindy Crawford, and the other 2 members of the Board of Canvassers, together with staff who had been engaged in the vote process in New Richmond, spent 9.5 hours going through the ballots for this particular race. And I'm just going to say they did so in a very professional manner, very thoughtful in all regards.
Now, approximately how close is this in relation to the date of the election? Is it a week out, 2 weeks out?
It was conducted on April 11, and the election was on April 3rd, so about a week out.
Yeah. Now, and just as people may not realize, because very few elections result in 1 or 2 vote margins or in statistical ties as of the date of the election or the next day after. A lot of those that are that close, sometimes we don't know a quote-unquote winner until the next day. But even that person that has the lead as of 24 hours within the date of the vote is not really the official winner until the canvass is done, correct?
It's correct. And so what happened, the board met and they said, we've had a tie. Then Wisconsin law says, you'll determine by lot the winner. So I believe what they did in this case, they just put 2 names in a hat and drew 1 name, and that was the winner. It happened to be Scotty Ard. At that point, the other party, Ryan Shirley, exercised his right to ask for a recount, and a recount of District 13. So 2 days later, they met for the recount.
Okay, so you have Board of Canvassers, and they go through all the ballots, and they affirm basically the same result as what had been indicated by the unofficial initial returns.
Yes.
But Scotty Ard was selected by lot as the winner. Recounts request, which is fully within the rights of either candidate, although usually the winner doesn't ask for a recount if their name is named voted by lot. So, all right. And so now it's 2 days after the canvass. We're now up to April 13, 10 days after the election. Then what happened?
To make kind of a long story short, it was ultimately determined that there had been 443 ballots cast, and there were 440 voters. So that means there were 3 more ballots
for that one particular county district.
For that one county supervisor district.
And this is what we need to keep straight too, because we're going to be throwing out terms like ward and district. And because the County Board of Supervisors has 19 districts, it crosses over different jurisdictions. It may include a township and part of a village or part of a city. It could be 3 townships. but ultimately whatever population was determined to be that district size since the last census, that's the county board district. And so you have to try and determine how many people are voting in that district by taking wards and portions of other districts that overlay those county supervisor districts.
That's all correct. So ultimately then they had 3 more ballots cast, 3 more votes than they had voters. So Wisconsin law says at that point you have to balance the number of voters with the number of ballots. And what the Board of Canvassers decided to do, and did so on also on advice of corporate counsel, was to basically take all the votes from all the wards. There were 6 wards in District 13, literally put them in a bag, and then each of the members of the Board of Canvassers, or 3 of them, reached in and pulled out a ballot, sight unseen. 2 votes that were pulled out to be discarded were for Ms. Ard. 1 vote was pulled out for Mr. Shirley. Therefore, at the end of the day, Ms. Ard lost by 1 vote because 2 of her ballots were thrown out. She then properly exercised her right to appeal to the local circuit court, which she did in mid-April of 2018. And that's when the process began before Judge Ed Vlack. And I'm just going to editorialize to say that I've now sat through court proceedings in each of the courts in St. Croix County, and Judge Vlack and all the other judges are really tremendous. They're fair, they're thoughtful, they're courteous, and that's how this case proceeded. But it then proceeded for about 4 months. And Judge Vlack ultimately rendered his decision in the case on 4 September. And he concluded that, I'll just say very quickly, 1, he had jurisdiction to make the decision. 2, a ballot that had been cast for Ryan Shirley was invalid. And 3, the process used by the Board of Canvassers when they reached into the bag was inappropriate when they'd thrown all the votes into 1 bag. Now, if you'd like me to go through a couple of those individually, I'll go through each of those as to why he decided what he did.
Okay. Well, I guess maybe briefly do that.
Let me just say jurisdiction. The court can't handle a case unless it has jurisdiction. Shirley argued, the judge, the law says you must object to preserve the item for appeal. And he said there was no objection made. Wisconsin law requires there be an objection. Wisconsin law says that in the minutes of a Board of Canvassers, you must record an objection. When the Board of Canvassers met, first thing in their minutes, they said, we'll record any objection. There was no objection recorded. So Shirley says, law says there has to be an objection. There was no objection, therefore you don't have jurisdiction. Judge Vlack ruled that was not correct. And he did so based on precedent of the Wisconsin Court of Appeals, a decision made by effectively our local district court of the Court of Appeals. It's called the District of the Court of Appeals, on a 30-year-old case in which they interpreted this law that said you must object to say, no, you don't have to object to a determination of the Board of Canvassers. And he ruled that there had been 2 determinations, 1 on the Shirley ballot, 1 on the process. Therefore, he applied what he had to apply, the precedent of the local Court of Appeals. The issue on the Shirley ballot was a voter had gone in and his ballot was an electronic ballot marked Ward 3. The voter went to the electronic machine and somehow he ended up voting in Ward 4. Now, nobody's claiming fraud on anybody's part or malfeasance, but there must have been a mistake somewhere, probably by a poll worker inadvertently marking the ballot or inadvertently touching the electronic screen for the wrong ward.
And of course, just so we're clear, we don't, everyone knows that votes anyway, that you don't sign your ballot or anything like that. So we don't know who the voter was that did this. And but how does a voter who is supposed to vote in Ward 3, now which ward was it, 3 or 4 that was in this particular supervisor district?
Ward 4 is in District 13. So a vote was cast in the race in the Ard Shirley race that on its face should not have been cast in that race.
Okay.
And there are 2 principles. Wisconsin law says in its constitution, you can only vote in a district in which you're an eligible elector. Mm-hmm. Well, on its face, this person could not have been an eligible elector. There's also the principle that the Supreme Court has said that we want to count any vote of a voter in which we can determine their intent. We do not want to disenfranchise a voter because of a poll worker error or some tiny
Even
mistake.
if they're not from that district?
Well, that became the issue. You have the two principles: the sanctity of you can't vote where you can't vote, and the sanctity of we know what you wanted to do, we'll count your vote. The court decided that the first principle should prevail. If you can't vote there, we will not apply the second principle. So the Shirley ballot was thrown out. So Judge Vlack said, we will not count that ballot when I remand this case to the Board of Canvassers for a recount. Second issue was the process correct in which they did the drawdown to balance the votes and the voters? And the Wisconsin law says that for each ward, you go through a special process, and you throw out absentee ballots, you throw out blank ballots, you throw out ballots that haven't been initialed correctly, and if at that point you still have an overvote, but you withdraw ballots, so you balance them.
So by balance meaning you have the same number of ballots
and
as voters.
And the critical thing is, do you do it as a district-wide thing, which is what happened in this particular case, where they threw all the ward votes into literally a bag and pulled them out, or do you do it ward by ward? And there can be a different result if you do that, because some votes might have had undervotes, some overvotes, and the court ultimately decided that doing a recount for each ward meant you did it ward by ward, not cumulatively. And so ruled against Shirley on that issue. Went up to the Court of Appeals in October.
Which is based out of Wausau for St. Croix County.
Wisconsin has an intermediary court called the Court of Appeals between the Supreme Court and the trial court. And that court received briefs in the case and rendered a decision on April 30th.
Of 2019. So now we're a full year and
several weeks into the process, in which they basically concurred with Judge Vlack's decision.
So Vlack's decision September, and we don't get Court of Appeals decision for 7 months. So during that 1 year and 3 weeks, there's no representative for District 12.
There's no representative for District 13. And also Wisconsin law specifically in at least two places says that in a circumstance like we're talking about, in an election where there's a contested issue, that the court shall act expeditiously.
Okay.
So I just leave that thought out there. Is expeditiously, in this case, until the Court of Appeals acted, 1 year and 3 weeks. At that point, Shirley had the opportunity to petition for review to the Supreme Court. Our court, it's not an automatic that you have a right to go before them for a final rendition in your case. You have to prove to them that your case is important, it has statewide application, and it's worthy of them accepting it. So on approximately the end of May, Shirley petitioned for review to the Supreme Court, but he did it strictly on the jurisdictional issue, because again, if he prevails on that, then he would prevail in the case. The court has not yet, as of July 3rd, responded to Shirley with their answer to his petition. And just one of the reasons why, they've been pretty busy with the Wisconsin legislature and the case with the governor against the legislature, in which they were trying to stop the activities of the Wisconsin legislative branch. It happened to be in the same court. And the court meets about once a month to decide which cases it will handle. And so the fact that they haven't acted shouldn't be held against them.
No, and in my experience, petition for review process still is usually 90 to 120 days, but not in a situation where they're asking for things to be expedited. And there are, at the Court of Appeals level, there can be such a thing as an expedited appeal, but you usually don't get three complicated issues that were here. Now, and I want to back up because you explained Judge Vlack's ruling on those three issues and how he could have ruled and what he did rule, but we kind of glossed over the Court of Appeals. Ultimately, their job is to decide, and if they had reversed on the jurisdiction issue, they wouldn't have probably gotten to the other two issues. But
the problem they faced was it was their court 30 years ago that said, despite what the Wisconsin statute says, you must object to preserve the issue for appeal. They ruled in a case called Clifford that the language was ambiguous and that if the Board of Canvassers made a determination on an issue, no objection was required. Now Shirley, if I can remember how he said this, and his counsel said it, basically said, well, just a second, it's like in court. If you're in court and you want to object to something that's happening, you say, Your Honor, I object, hearsay. And then the judge can either overrule you or sustain you. But if he overrules you, you do not have to object again. And that's what Shirley's saying. Judge, we're not arguing whether she has to object on a determination. We're arguing she had to object in the first place.
Okay.
And if there's no precedent objection, you haven't followed state law.
Right.
So now it goes up, but that court, by other precedent within that court, the Cook decision, cannot overrule itself. So even if it thought that Shirley was correct, it had to follow its previous precedent. Only the Supreme Court can overrule.
Right.
overrule.
But in the analysis, then, so they basically upheld themselves and
Yes.
applied their own ruling on the jurisdiction. Then they get to the other two issues.
Yes.
And the other two issues, should the ballot be thrown out? The Court of Appeals agreed with Judge Vlack that it should.
Yes.
And they also agreed that the process by which the leveling was done was inappropriate.
That's correct.
So we could have a situation, because now the petition for review is on that one issue. First of all, the Supreme Court even decides whether it will accept the petition. It doesn't have to, and they accept petitions somewhere between 10 to 20%, depending on the type of case. So it's an 80 to 90% chance they won't accept the petition. And even if they do, it doesn't necessarily mean that they're going to rule in Shirley's favor. It just means that they want to rule on the issue and kind of settle it as to whether or not the Court of Appeals. It would be very interesting that the Court of Appeal of the Supreme Court, if they take the petition and then they rule that the Court of Appeals, which upheld its ruling from 30 years ago, that both 30 years ago and the current ruling were misapplications of the law, and which has been everyone's been operating under for the last 30 years, is illegal, that the court shouldn't have had jurisdiction. We could have a situation where then the Supreme Court won't rule on the other two issues, and in effect, that's the legal question, or the legal argument is that at that point the analysis should stop, and even though the highest court that's reviewed it and said that the votes were, that a Shirley vote was improperly counted and the Board of Canvassers process was also wrong and illegal, that there would still be a declared winner according to the Supreme Court.
That's correct. They would never get to the merits of the case.
Okay.
Because they didn't have jurisdiction, if they ruled in Shirley's favor.
Right. Now, here's the question to go back, because between the canvass, which was done on April 11th, and the recount 2 days later, you have the canvass.
I think it was April 9 for the canvass, April 11 for the recount.
Okay, sorry, I didn't mean to get that switched around. So April 9, and the date of the election was?
April 3.
April 3. So we were roughly just shy of a week and then just over a week. So the canvass is 6 days later. And the canvass, at that time, declared a tie. And that tie was declared based on 443 votes. Out of 440.
Based on 443 votes, but the actual vote count was 213 for Shirley, 213 for Ard, 2 votes for other people unknown, let's say Jones and Hanson.
Right.
And on 15 ballots, nobody voted for the office. Mm-hmm. So it was a 213-213 tie.
So it was truly of ballots, 443 ballots cast, and only 440 voters. And out of those 440 43 ballots, 426 were essentially for it, and that's why you had the tie.
Yes.
Now, so my question though is, why did the Board of Canvassers at that point not rectify the overvote situation? Why did they allow it to go to recount and then have this recount take out 3 ballots?
To be honest, I'm not sure what the specific role on that date is for the Board of Canvassers. I think they're just certifying that that's what the votes showed.
Right.
at 213, 213.
Because even if it didn't, it just happened to be a tie.
Yeah.
If it had been 1 or 2 votes either way, you still would have had probably a request for a recount, which a request for a recount says, now we start all over, and it's a very long process, correct?
Yes, and as I may have mentioned earlier, you had the Board of Canvassers and assistants from New Richmond who had been the election managers there, came in, and in a very thoughtful process, they went through it laboriously, checking every name that had voted, every ballot, and they did everything. I would say we'd be very proud of them as citizens for the honesty that they showed in going through it. And any mistakes that were made were simple mistakes that honest people can sometimes make.
And again, when you say simple, any mistakes they made, any alleged mistake would have primarily have been that whole Ward 3, Ward 4 vote, correct?
In the sense that they counted the vote. And what actually happened there was a notation in the minutes, and the minutes are correct, but and both parties agreed to the minutes. They said, we agree, these are an honest reflection of what happened. But the minutes essentially reflect that we had a ballot marked Ward 3, voted in Ward 4, and it counted for Shirley. And then there was a call made to the Wisconsin Elections Commission. And it just simply, the notation simply says there was a call made regarding ballot count. It doesn't say it was regard to the Shirley ballot. Presumably it was, but it doesn't say that. And there's no long discourse as to what happened on that. But the conclusion, and this is only like a half sentence, Wisconsin Elections Commission said, leave as is. So the Board of Canvassers then left it as is, a vote that counted for Shirley. Now, there was no objection at this point by anybody. You might say, well, the fact they made a call to the Wisconsin Elections Commission, what does that reflect?
And that was done on canvass day, not a recount day.
Recount day.
Or it was done on recount day.
Recount day. And then with regard to the process by which they drew down the votes from 443 to 440, there again was discussion as to how they should do that. And Ms. Ard at that point made an observation that the Wisconsin Elections Commission had a process like they did when they had the by-lot selection earlier in the process, and that it should be followed. And there had also been another call to the Wisconsin Elections Commission. And again, we're dealing with a couple of different things here. Although the request for the recount was in District 13, the Board of Canvassers had also decided to count the votes in District 12. As it happened, when you combine the overvotes in one district with the undervotes in the other district, they exactly equaled. So the guidance they received from the Wisconsin Elections Commission, a staff member, was, hey, since they balanced, forget it. You're done. You know where the error took place. The Board of Canvassers said, well, just a minute, we have to follow Wisconsin law. And we're only authorized to look at District 13. We know what happened in District 12, but we're only authorized to recount in District 13. So even though we received that guidance from the Wisconsin Elections Commission, the law says we have to draw down from District 13. And that's when they then said, let's put all the wards in the basket and draw out 3 votes. And that's ultimately was decided to be incorrect, as I said, by the court, that they should have done it ward by ward. So what'll happen in the ultimate, if this case gets if the Judge Vlack's decision and the Court of Appeals decision is upheld by the Supreme Court and it's sent back to the Board of Canvassers, let's just say in September, the Board of Canvassers will be in a position on each ward. They'll be throwing out the Shirley ballot, so the votes equal in Ward 4. The votes are either exactly correct or undervoted in other wards, and the only ward left is Ward 10. And Ward 10 had 5 overvotes. So if we left it at that, what would happen, I believe, is that the Board of Canvassers would look at the votes in Ward 10 without looking at what the vote was, but they'd have them spread out or in a bag, and they would throw out 5 votes. And then there would be a recount of the votes that are left to see who won. And if my math is correct at this point, Art is ahead by 1 because of the vote for Shirley being thrown out. So if one of her names is thrown out, or 2 of her names is thrown out, she wins. If 3 of her votes are thrown out, it's a tie. If 4 of her votes or 5 of her votes are thrown out, Shirley wins. So we don't have because the case has been decided where Shirley's lost the court case, doesn't necessarily mean what the result will be of the next recount.
So it will have to be remanded back, regardless of whether the Supreme Court takes the petition. It will have to be remanded back for further proceedings to correct that legal procedure on the ward-by-ward issue.
I believe that's true unless they decide jurisdictionally that the court never had jurisdiction to decide it, and the Board of Canvassers' decision would stand.
Okay.
But if they send it back to correct it as suggested by Judge Black in the Court of Appeals, yes.
But if there's, in this Ward 10, if there's 5 votes for that particular county board seat that were not cast, these are the non-vote ones, then everything would stand with the 1-vote margin. If 5 out of 5 were non-votes, or if there's a 1 non-vote and 2 for each side.
Yeah, once you get into the issue of which votes do they put in the bag?
Right.
Do they somehow try to segregate? Do they call a vote? If a voter didn't vote on a ballot for this election, is it a blank ballot? Mm-hmm. In which case, is it thrown out? If there's a problem with the initialing of a ballot, is it thrown out? And there was a notation in the minutes that there was a problem with the initialing. So I made the comment earlier, if there was no other issues, you'd just be left with the 5-vote, pull it out. But there are other issues.
But you do look at the ballots before you decide there's an overvote, because if you have 5 invalid ballots, then there's not an overvote.
Ultimately, you have to look at the ballots to decide which ballots you throw out before you do a drawdown.
Right. Yeah.
Yes.
So we're still not done with the process. And the other thing is, if the Supreme Court were to take the petition for review on the jurisdictional issue, they'd have to have oral arguments. Well, first they'd have to have a briefing.
Briefing.
And that generally takes a minimum of 90 days, even in an expedited situation.
Absolutely correct.
And then they'd have to get it on for oral argument, which is another fast track would be 60 to 90 days would be very fast for an oral argument after the briefing is done.
You are very knowledgeable about the Supreme Court of Wisconsin, yes.
So 5 to 6 months out from the determination the petition for review is granted, which could come late this month, it could come in August. But we're talking about, now we're into January, February, which by that time we're going to be past the time to get your name on the ballot, the nomination papers in, or the declaration of candidacy, correct? For the next cycle, for 2020?
I believe that most of those papers must be filed in December of 2019 for the 2020 election.
So it could happen that Supreme Court could not have a decision on this until after the next person is elected to that district.
It's possible, and then I suppose they could say it's moot.
Right.
Because these two folks...
Once we get to April of 2020,
that's right.
It doesn't matter.
It doesn't matter.
And I know from experience, too, that appellate courts are very wary of rendering decisions just for the principle of the matter. If it's not going to make a difference, moot issues, typically, they do not rule in. Now, here's my question, going way back. In this situation, it kind of strikes me as interesting. Wisconsin law does not give the option for this type of situation where you have basically a legal non-determination of a rightful seat holder. Why is not the default that the person who was holding the seat, because the election has not yet decided who should be the next person, why isn't the person that was elected in 2016 still in there?
Well, I just think that's why we have elections, is to decide every 2 years who should be there.
And but we have elections to give people, the voters, the constituents, a voice.
But very often in administrative offices or cabinet positions, the holdover continues.
Right.
That's a typical thing.
That's what I'm doing.
But I never heard of that in an elected office.
Right.
And so you have your term, and when that term ends, unless you're reelected for elected office, I don't think that principle applies.
Right, but it's a great philosophical argument. I don't know if it's constitutional or if it's statutory by the legislature, but it would seem to me that which is worse, having nobody in that office for almost an entire 2-year term, or having somebody who was rightfully elected just serve an extra amount of time, whether that's 2 weeks, 2 months, or 2 years, until you have a legal, rightful determination of who should succeed that person.
It's a very reasonable suggestion, and I know that certainly over coffee, a number of folks have talked about what do we do with poor New Richmond, the southern part of it,
right,
that doesn't have representation. Now, I don't think it's really hurt them, because this is a nonpartisan body of county supervisors. It's not the House of Representatives, right, where they're going at it tooth and nail.
And we have some states, Minnesota's one, in the past there's been others that are either at a tie, literal tie, or one vote off. In this case, though, whether a rightfully elected person should still be in there, it shouldn't really necessarily be a partisan issue, especially in a nonpartisan race. But still, I would think the civic part of this is that we should try to give every voter their voice, whether it's the legislature, the executive branch, or the judicial.
And I will say, I think the county supervisors board that are in place are very sensitive to the lack of representation in that district. And anything that relates to that district, I think gets very special attention, and we try hard not to do anything that a representative would have said differently on had they been in place.
And that's a very, civil way of doing it, because typically when you have area representation, we don't have at-large representation on the county board. You are representing, and there's that whole philosophy. Do you give a voice to your voters, or do you vote on your own conscience? That's a whole separate topic we don't have time for. But ultimately, you wouldn't gang up on an unrepresented district because of how rare it is.
Absolutely.
And so, Bob, I really appreciate you coming on, and thank you for helping us walk through what is a very complicated situation.
Well, Jamie, I enjoyed being with you, and you've got a great grasp of the issue, and appreciate that as well.
Well, we'll be watching the news to see what happens at the Supreme Court level, what happens if it's referred back to the Board of Canvassers, and it may not be. And then we'll ultimately see what happens in April of 2020.
Absolutely.
All right.
Thank you so much.
Thanks for being on the show.
Appreciate it. Thank you.
And thank you for watching another segment of Western Wisconsin Journal. I'm Jamie Johnson. Keep watching.